I'm putting my back here. Sure. About to men with the biggest stomach.
Video scared. Just being in front of one tail. It's a very nice allegation.
Sebo, yangu onyimirire wange. Kamera zerera. Aba serugo. Eno banana. Omulaba bulungi ate ekirala omulamuzi awaba ogiteeka wano bawano babadde bawambyewo MBS ono eyaffe eya NTV gikwezi awo oyimiridde
And then we can respond to whatever shall be contained in the application. So humbly pray.
Totally eating my submissions. Six of the application. I'm aware that it has been eight. Do that. It is formally. Formally. Lord, taking these part here. So where you have questions arising about where here.
In the constitution, especially due to
Lord, in that way.
they have, it has not yet been fixed. They have failed and they're saying, let us hold this business. Yes. No, they have it in this court. Yes, now in the meantime, they want us to hold this proceeding.
I would have conceived that tomorrow, perhaps at the Monday, the adequate time. And I'm glad I noticed that. What it is to fix the application. So that the judge can obviously thereafter the position arises. Go to the prayer for just 1 month. Way, way too long. Prayer for 1 month. Way too long. Way too long. Various guidelines are established.
But he's raising new matters in this.
It is my lord. Just to add on to the submissions of Council Kalibala, one, two issues. The claim by the Assistant DPP that they are not aware of this application, rather of the application and the petition, is rather disturbing to us. Yes, it's neither here nor there. My lord, they seem not to have moved with the technological shift within the judiciary here, the judiciary system.
You see, they should
With
we are
the
not tagged. We
digitalization
cannot access if we are not tagged.
of the justice system in this country, my lord,
After the court has identified,
they are presumed to be aware. By construction, they are aware of this matter. By construction. The application was uploaded on Xmas. It's there, and they know it. With all due respect, it would be imprudent for the assistant DPP and the entire team to appear this morning at 11 to argue out a matter of this magnitude without checking on Xmas. Imprudent of them. It's routine, my lord, these days. All of us, before we appear before court,
we can only
we check even last minute,
pleadings after we have been.
a few microseconds before we entered here, we had to check, is there any new development? And my lord, once there is any document uploaded on the system, all the parties get notifications. And I'm sure if they checked their gadgets, the notifications are there.
Not there.
So that is a lame excuse. As I said, my lord, with all due respect, it's laziness on the part of the assistant DPP. And that shouldn't be used as an excuse to come and avert the course of justice. That said, by Lord, the last issue I wanted to address, my mind too, and the court, is the prayer they are making that despite the fact that there is a pending application for stay, court proceeds to administer retaking. That is the list that will come from the office of the DPP. I think it would be safer on their part, my lord, to first address their mind to the gist of the petition. If a party seeks an order of stay, it's imperative, my lord, that we look at the crux of the matter. In effect, my lord, an application for stay is about arresting the proceedings. And the court is duty bound to look at the reasons as to why the party is seeking to arrest the proceeding, halt the proceeding, bearing in mind the danger of proceeding to the next step before addressing your mind of the reasons being advanced. So therefore, it goes without saying, since they have not looked at the online application and they have not been physically served, so they don't know the issues that are being raised. And it would therefore be imprudent on their part again to ask to proceed in such a casual manner. My lord, for the emphasis sake, as I conclude, had they taken trouble to look at the online pleadings, I am sure they wouldn't have made that prayer that we proceed, because these are very, very serious issues we are taking to the Constitution. Actually, we have taken to the Constitution. Very, very serious. Going to the root of the pleadings, of the proceedings before. Number one, the impartiality of this court. Anything that touches impartiality of the court is so central to the proceedings that court must be sensitive.
You see, he's raising new matter
In taking an end decision as to whether to proceed or not. The other issue, my lord, again with utmost respect to this honorable, the question of the orders being sought of the removal of a judge. It's a very serious matter. My lord, one needs to first critically reflect on those issues before you proceed to administer. And these are the issues we intend to argue out in the formal application, my lord. And I'm not attempting to argue them out, but I was just emphasizing the point that this is not a matter that should be handled in a cursory manner. Overlook the issues that are being raised and then proceed with the pre-taking. I reiterate the prayer made, my lord, that you be pleased. And this is the procedure, my lord, to dispose of the application before you, then the rest will follow. I do so, my lord.
My Lord, I would like to say a few things, but first to tell my learned colleague, the Assistant DPP, Mr. Jatiko, with a light note that he has no duty in law to oppose every application made on this side, especially if it is procedural.
My lord, I think this is grossly wrong. No one is opposing any application. No.
You agree, my lord?
It is a matter which is the same defense is placing it before the
No.
court. We have not known. So to say that we are opposing.
Let me finish why I said you are opposing. We are seeking for the court to halt the process until the stay application is heard. But Mr. Jatiko says, hear the plea first. That's what I heard you say. Unless you, he said that the plea should be heard. Unless if I misheard him, that is where I'm coming from. That in essence is opposing the stay. Because once the plea is heard, the proceedings will have commenced. The very proceedings we are trying to stay. And this is a procedural matter. There is an application which is going to be served at the end of the day. And on a matter, like my learned friend Arias Lukwago, the Lord Mayor has elaborated, it's on matters that have been canvassed before this court, so it's not on any new matter. So I would like to refer the court to Article 28, Section 1 of the Constitution, about the right to a fair, speedy, public hearing before, these are the two operative words, independent and impartial court, if I may leave there. That is the area the accused persons are contending. They want their petition before the High Court to agree with them, or disagree for that matter, their contention that they are not before a fair, an independent and impartial court. They have given their reasons. So this is an Article 28 fair hearing issue, and therefore the stay of proceedings is critical to that extent. We would pray, as has been canvassed by my colleagues, that these proceedings should not continue until you dispose of the stay application.
My Lord, you could have that statement expanded from the record. Now it's important to just make sure that we have a guided procedure so that we don't have to respond to each and every.
Yes, that the petition before the High Court is to determine these issues, because the recusal was about impartiality. The reference to the court, which the court rejected, was also about the same issues. So the gist of the application, that is what is before the court for trial. I would also say it's already been canvassed that asking for 1 month is unreasonable. And I would like the court to note that although they
Now, what is missing? A very simple prayer from my colleague, Mr. Kanibali, was for court to kindly agree to fix it so that we can fix it. I don't want to assume that the court, the sitting guidance of this court, to fix it. I'm sorry, the word might be directly, but shouldn't do. My lord, court is kindly obliged to fix it during the proceedings today. It can affect service on our colleagues because they are principal officers, so that we save time. That is it. The second request is that, in light of what is in the application, that court is minded have the application disposed of and then we return to criminal session case number 355. So, my lord, before this court is an application which is pending the case. If we ask, my lord, that it dispose of the request of justice, and then we return. My lord, the application does not seek to nullify the criminal case. There is no such procedure. So there is no danger, there is no prejudice to the criminal case if the application. I love that so simple. I know that's the final submission.
My lord, just to set the record straight, but not overrule the submission of my colleague being the final submission from our side, but just to set the record straight, because some matters have been put on record. My lord, regarding the purpose of Xmas, it's important. It's important not only for the parties before you, but for all court users. The purpose of Xmas, my lord, was to ease the process of managing biddings. My lord, Xmas has never been intended for experts or IT experts only. And I want to go on record, my lord, yes, I'm not an expert in IT. I am one of the beneficiaries of Xmas because I'm a court user. All court users. Actually, I'm a court officer, not even a court user. I'm a court officer. That is one, two, my lord, and it's also important. One needs not to be linked to the server, but to the case. And I'm sure in this particular matter, the main session case from which the application arises is on Xmas, and the prosecution is linked. So whatever pleading that arises out of the main session case is brought to the attention of the prosecution before even service is effected. That is the notification I was talking about. And I was asking them to be honest enough to tell this honorable court that they received the notification, which they ignored. It's not practically possible that a session case is uploaded on the Xmas and the application filed there is not brought to their attention. It's not possible. Otherwise, my lord, I want to sum it up. They want to impeach the validity of the pleadings on Xmas. That's what they are seeking to do. But unless one gets physical service, they can come and claim ignorance about the matter. And that is a very serious one regarding administration of justice. The last one, my lord, is the danger we talked about. We have not talked about Article 44. In all this we have discussed here. That should the pre-taking proceed will amount to violation of not only Article 28, but also Article 44, which is non-derogatory. Rather, non-derogable, sorry. Article 44, which is non-derogable. I'm sorry, my lord. And that should be instructive. Now, this is the very final one, my lord, from the application. I beg you to move.
I have very carefully listened to both sides. I will not reproduce their submissions, which are for record, but briefly, I will now proceed to make the following remarks. That court received criminal application number 814/2025 from Xmas. This application was filed on Xmas on 3rd December at 7:36 p.m. From the court record, the Registrar of Criminal Division allocated the same application to this honorable court today on the 4th at 9:15. Therefore, prove that this application has not been fixed by the time this matter came for hearing. I am aware that this session case was coming for taking, but it is my considered view that for the interest of justice, since there is a pending application for stay this main case, it is my view that the application should be disposed of first, and then we shall proceed with the main. Therefore, let us go to the main application for stay, give schedules. Then after giving directions and the schedules, come back to give a date to this main session. So,
Most obliged.
I have already got the application successfully and I have it for me. So I have now directed that must be disposed of first. Let us now quote it for directions. May I know now this, we are just going to agree on check.
Good. Let me just check before we go. Terms of appearance. I just
Yeah,
because the number is what you note for the appearances, this matter, this council. Both the state and the applicants. Same.
Mm.
Lord, to be very brief for this application, simply seek God's directions on it. Which we beseech the court find week. Lord, the timeline that the court gives us able
Actually, now, no, it's up.
today. We are going to serve today. Yeah, we might even serve today. We're going to serve. Only physical copy.
Let me hear from Council. What's up today?
And if we are served today, we can be able to make a response to this court by 18th. 18th of December.
Lord, my humble prayer is that the court directs it. I remove the one. One is three. Just remove one. The other one is okay. Then, if they respond on the 8th, we have 1 day within which to file by the 9th. I know after that.
To address concerning what my colleague has said. I would to it appears the counsel believes that the prosecution really has no other matters they are attending to, as they are just sitting and waiting for this, my lord. So it's unfair just to say remove one and make it eight. And my lord, the prosecution already has matters that are fixed before panel cases for next week, my lord. And it's common knowledge there are matters fixed before the ICD, Uganda versus Yahya Mwante, Tumba Wamala, where this team is the prosecution team in that case. So, and my lord, the defense has had since 6th when November. So to stampede the prosecution with a matter that we have not even been served yet, my lord, we pray this honorable court take that into account.
If I may do the rejoinder. Lord, if I may. The prosecutor says he's overloaded next week. Although the application is on matters that he has had severally in this court, I'm just reminding the court to see the defense point that these gentlemen, whom the law presumes innocent, have been in custody for 1 year. We would have no objection to the prosecution having all the time they need or they wish for if they dropped their objection to bail and the court was able to grant these accused persons who are presumed innocent and who have been in custody for 1 year leave to go to their homes and be with their families during this season. If not, let's come back to court on the 10th. I'm praying that. Yes, I'm associating with him that 8th, we respond on the 9th, then on the 10th, let's come back and dispose. Else, let them drop. Yeah. By Monday. Monday the 8th. Yeah. I'm saying the same. 8th, we respond the way Ms. Council Karibara suggested on the by the 9th, and then we come back to court on the 10th. 1 year is not a short time for people who are presumed innocent and who may very well end up being cleared by this court being behind bars. And that's why its own motion. So if we are not bail, then let's come back on the 8th, on the 10th, and settle the matter.
Then on 9th, at the hearing, we shall file submission.
I know you want your clowns the other side. I know you want your clowns to come and shine. Your clowns on the other side. This team is here. The clowns at the other side.
Let me ask this. And the state, what is your view? Assuming we proceed now, orderly, and we read the application, is it fair? Or still you say the judge is not fair? Assuming, because now we are struggling on when to file a reply, when to file a rejoinder, when, assuming you have the application, because We come here for hearing of pre-taking, isn't it?
Yeah.
Assuming we are putting up swim
Yeah.
with application, as if they respond orally. And we leave this business of is it fair to most of you? I don't know. No, I want us to agree. So that we had come here for hearing that it's okay. But now I am saying that you are taking this one once here, this day. I don't know.
I think, my Lord, the way to solve this is that urgent applications are not given the same time for responses as ordinary applications. And when it is urgent, already, you see, it's a formal application.
I agree.
And
But I'm
the
trying to
right,
scratch your mind.
the right to fair hearing is cuts both ways. So their response on record is necessary, but the request for time.
No, that one I'm going there having.
So I'm saying, in considering the request for how long, it's the urgency of the application. And in our case, we are saying,
You are saying you are not couldn't be there to proceed.
yes, yeah, but I'm also telling the court and the defense to remember that gentlemen who are presumed innocent,
That one is okay.
three of them,
Let us really separate.
yes, it's a part of
Separate
it.
the process and-
It's part
So
of it.
that also you are saying it's not fair. It's the same. But it's not a ruling, by the way. This one I can assure you
Yeah.
it's not a ruling, but I am concerned. Before I go to
My Lord, I would concur with senior counsel because
Thank
if
you.
they are not prepared to proceed, now what of us who have not even seen the
We're talking about that.
it's okay now. We have
And we can't be the ones leading. That's why
They need to fight. We shorten the time.
ate twagala kaluwa ne mabirizi ze bagenda okujagiwinga baabalizi abalizo twagala bali babiri bagenda ejiwozi if you're not ready, why should we prejudice you?
Only that, if they are here, we can't affect oneself. You have the right to
they have also filed the bail application. This one?
These are directions of this application number 814. These are directions. I have decided to give each party 1 week, including court. Therefore, 1 week will operate as follows. The constitution should be served today, which is first. And then, when they are served today, 1 week from today, while you are reply, this takes us 1 week, takes the constitution on 11th December, file and serve. And then we join the 8th, I've given it also 1 week. That is 18th December. And finally, this application on 22nd December. The remaining case also is fixed or mentioned now when you on 22nd of this month. Okay. Now, there is what God is
In the miscellaneous application to the issue of 2025 primary
I want us.
The appearances are as before on both sides, unless if the learned colleagues for the DPP. Speaker.
Richard Billy Bumbuka, Chief State Attorney,
It is true.
and Joseph Chom Muhendo, Chief State Attorney.
We requested be stood over to the same date.
The clarification I needed from the team is we have fixed this application for stay.
You can bring them when we are addressing folks.
This application for, you have a copy, read order sought in this court, order number 1. This is order.
Go ahead.
Whoever has the code. Hey. Yes. I am now just I need a clarification on 814 this. This is the one we have now. Order number. Order.
Hearing of the concession case.
Yes, yes.
Case 335 is state. Pending resolution of
So this order one sort is for stay of that main session. Read B.
the applicants will be released from custody.
So now, I have lost this same two accused persons have application for bail, which has been in court since. Suga,
Yes, my lord.
on S3,
Yes, my lord.
there is application for bail 698. Now, honestly, we cannot, we must agree. Now we want again, when we are adding this, we add state that is from their order number 1. And then we add the bail. So then we must agree on this. So I don't want us to come on that day and to start from zero. Because this is the same court, the same accused person, the same. So there is a pending application for bail. Now we are making another application for bail. So let us now give direction so that when we come, we are adding step because they will have 5. I guess they are filing on this bail because there are 2 orders. Are you getting it? Then what about this? We can't keep adjourning it. Which is the same court, the same accused, the same lawyer. So we can't now have this step. So we must agree on this today. So when we are coming, you are the ones now, we have a problem with time, isn't it? We have a problem with time. So let us sort out these different now orders so from the same court by the same.
Hello, 282, just to explain.
Yes, 282.
Before we get into the just to explain. 282.
Yeah, we must before I wrote before I just want the direction.
282 is the standalone application.
For what?
For bail.
Yes.
It filed early this year.
Yes.
814, the prayer for bail is consequent upon
It is also
So
paying
it's
the
not
same
a,
person.
it's not a standalone bail application.
It's the same
It is
prayer.
only, it is the same prayer alone, but it is not a standalone application. It is premised
If
on
you want God to go back, to release that day.
Yes, but my lord, the release is based on.
Also, what I'm suggesting, let us know if you are arguing stay and then here, then this one is strong. Because it helps us
We can take
then
instruction.
we can say with this one we only argue stay only.
No, my lord,
This one
in
we only
814,
come to stay and then
in 814 we take agriculture. But my prayer is that you allow us to take instruction on 282. 282, first one. And by the time we come back, or before we come back to 814, we will formally communicate the instruction.
One point which we have to settle the matter.
yes.
Once there is an application for stay, the application pending the resolution of the case in the constitutional court, the success of that case would render the issue of the hearing of any application before the court. We will be going to another court. So once there is that application,
What I'm saying,
the
let us
success-
agree which one we are proceeding. We have this one for state as prayer. We have pending applications for paying. I want guidance on that.
Let
But
us,
we can't have both there. We can't listen to both.
in the application before you, the one you have just read,
This
the
one.
first prayer is stay.
Yes, and there is a
And we
prayer.
are very hopeful that we are going to be successful. Once you grant stay,
It's one application.
it's one
The
application,
receiving application is on pay.
prayer number one. Once you give number one,
That one I have no problem. My question is on orders on B.
once
B.
you, once you grant prayer one, and it's very strategically placed. Once you grant prayer one,
What I'm
you
saying,
can't proceed to prayer two.
before there is a prayer number B, B one has no problem. We have D. I think that we can take what Karbala is saying. I have told you that we shall agree on that day. Because we are adding this application 180, 104. We are adding step, we are adding reason pay on that day which I gave you. I am saying we have another one.
My lord, let's take, if the court will permit us, let's take instruction on how to manage to it.
Yeah.
The obvious thing is that if one force succeeds on this prayer, 282,
What I'm saying, we shall agree on which one.
814.
That's what I'm saying. I am saying if we are proceeding with this 184, then we can't add order B. You're getting it? It is for release. If we are saying we proceed with order, stay and release, then we must conclude this one.
In faith, if you want to grant bail of your own motion, and you
The
can,
application is already
let me
before.
just,
Yeah.
we are before you, you still can also direct of your own motion.
I am now directing.
I've said so twice today that you can still have power.
My direction is
Our
this.
application will then be rendered, because we will drop them.
My direction is just as Karbala has said, look at this application where there is an order for this. And then look at this one pending. Then on 22nd, that's which way to go.
My lord, the time on the 22nd. just looking at the time because I was filling in the application.
So let us know this one is they report the position of this of the application. Okay. Nine, eight. I don't know whether it's happened. Last time we were not here. I don't think that you have served, so you serve also. I went back to take thank you. But this one, so I'm saying, the position is serve. Okay. Position. So in this for serve the prostitution today, they can find the trial by evidence, and when I any things, they matter of come.
Bro, leero badde fata ogenda kukola interview. Microphone. Everybody else. They do. I like how you say that. Byange gye wangambye sawa.
Security, guru.
The way they're standing the display, the way they're standing.
That's how they stand.
As if they're waiting for the president.
Is the president party?
This is a president. These three are president.
Besigye is a party president of PFF.
By the grace of God, they will be president. I don't know.
Interview mpa bali batugobawo kati tulina kukolerawo ekimanyi nti nno baba tebaagala alwenawo wano kubanga waweewo awo abantu kansooka nzijeyo omuzindaalo mbadde ngwerade naye ebintu ddala ebyawo
sente zaffe zetulyako ng'abasajja sagala ndyawa
asigenda kuwa ŋŋanda unanoonya nsajja sakolindeko katono badde njeerabidde oba ekitongole ogwomuzindaalo
nange badde
mutasajja
wayogera
Harriet, I'm good. How are you doing? Oli bulungi? Ndako tukole interview. Just a second. Tukole interview tugende.
Tulina kukola interview.
Abana abasajja be banaatuwa interview. Oli mu kudduka kati atudda tekiraba engeri gye nzikwatamu ani ono avuddeyo tekuli linnya anko oyo oba tolina sente oyinza obutagirabako you may not see agenda mu 3 interview njazi